Hello everyone and welcome. My name is Dan Sampeo and I'm very excited to be opening today's Mondac Future Series event in partnership with Fasken and the Canadian Corporate Counsel Association. I'm thrilled to introduce you to our terrific panel, Alex Cameron, Kateri-Anne Grenier and Daanish Samadmoten. Alex Cameron is the co-chair of the Privacy and Cybersecurity Group at Fasken. He has a leading practice in the areas of cybersecurity and privacy and is consistently sought out in these areas by clients from all industry sectors. Alex has helped clients respond to large-scale cybersecurity attacks and data breaches involving many millions of affected individuals. He has also acted as lead litigation counsel in defending clients in landmark data breach class action proceedings. Alex obtained a doctoral degree in privacy law, is ranked in the highest band in the Legal Rankings Guide's chambers, and in the Best Lawyers in Canada, and was named the 2020 Toronto Privacy and Data Security Law Lawyer of the Year. Member of the Quebec Bar for more than 20 years, Kateri-Anne has in-depth knowledge of issues related to access to information, federal and provincial law, privacy law, and the protection of personal information. She has assisted clients in responding to multi-jurisdictional data breaches involving personal information and employee personal information, including review of disclosure obligations, internal and external communication strategies, reporting to regulators and affected individuals, and the conduct of investigations and implementation of recommendations. She advises and assists clients with building privacy compliance programs in relation with recent amendments to Quebec's privacy laws. Daanish Samadmoten frequently advises clients on various privacy and cybersecurity matters by providing practical and strategic advice in respect of privacy compliance, data breach incidents, and privacy litigation. Daanish has assisted numerous clients about their legal obligations and litigation risks, reporting to privacy regulators, working with forensic and data management experts, and drafting external communications. Daanish teaches cybersecurity law at the University of Toronto Faculty of Law and is a certified information privacy manager. Alex, Kateri-Anne and Daanish are our future series speakers today, discussing cybersecurity and ransomware trends in Canada and abroad. I'd like to hand you over to Alex to begin. Thank you.
Thanks very much, Dan. Very briefly, by way of overview, the topics that we're going to cover are up on your screen there. Daanish is going to run through ransomware trends and service provider breach incidents in terms of what we're seeing in some practice issues there and trends. Kateri will touch on the new changes in Quebec, which are quite substantial. And finally, I'll wrap up with some discussion about governance and boards of directors issues in relation to cybersecurity, some privilege issues, and touch on some law reform. I also will just mention at the outset that we received, firstly, tremendous registration for this event and also a tremendous number of questions in advance of the session. And so thank you very much for submitting those questions. We have taken those into consideration and we will try to address as many of the specific questions that were raised during the course of our presentation. We may also have some time at the end for some additional questions, and please do submit them as we go here if you like. You do have access to the handout of materials in the web format here, the Cybersecurity and Ransomware Trends PDF that you, I'm sure, can see there. That includes the materials for today, as well as some links to additional resources on some of the topics that we will cover, and a little bit of information about us as well. And you will also receive a follow-up after the session with those materials, and I understand access to a recording of the session. So I mentioned those as housekeeping matters at the outset, and with that, I'll turn it over to you, Daanish. And we could move to the next slide, please.
Thanks very much, Alex. So as Alex said, I'm going to start by covering ransomware trends today. Alex, Kateri-Anne, and myself act as breach coaches frequently for clients, as you sort of heard from the introductions. That's just an industry term. A breach coach is basically just a lawyer that assists an organization dealing with a privacy or cyber incident from various perspectives, from a legal perspective, from an incident response management perspective, from other perspectives. And so one of the reasons we wanted to talk about ransomware today and ransomware trends is that it's one of the most common types of cyber attacks or cyber incidents that we assist our clients with. And so that's why we wanted to discuss it today. For those of you who don't know, ransomware is a type of virus or computer virus designed to block access to a computer system by encrypting files until a sum of money is paid in exchange for what's called the decryption key or decryption tool that can decrypt that virus and allow you to have access back to the files. So basically, the ransom part of that obviously is to pay the money in exchange for the tool. As I said, it's one of the most common types of cyber attacks that we see and often can be the most impactful cyber incident affecting an organization, and from an operational perspective anyway. As you can imagine, most organizations in today's world would rely heavily on computers. So an attack on those computers that makes them unusable can have a very severe operational impact. So we'll talk today about some of the trends that we've seen in our practices in respect of ransomware. So the first one, as you can see on the screen, is the ransom demands and the payments are increasing. That's been a trend certainly over the last few years. This is likely due partly to the fact that the amounts of demands are even larger than a few years ago because of various factors. One of those is in respect of the double extortion method I'll talk about in a minute. Just for context, though, we now regularly see ransom demands over $1 million. That's US dollars, and the threat actors always kind of use US dollars. Whereas a few years ago, it was common to see ransom demands of 50,000 or 100,000. That was fairly common. We also now regularly see ransom payments of over $500,000 in cases that we assist our clients with. So certainly a big increase than a few years ago. Just as a further evidence point for that, there's a company called Coveware, which essentially is a ransom negotiation and facilitation company that basically helps you pay a ransom if you decide to pay one, because obviously these payments are not made in cash; they're often made in cryptocurrency, usually Bitcoin, and most companies and organizations don't have that just laying around. So you need someone to assist you in facilitating that payment. That company has releases a quarterly report of data that they've aggregated on an anonymous basis, and their quarterly report for Q2 2022 indicates that the average ransom payment went up 8% from even just Q1 of 2022. So the average ransom payment they see is $228,000. So obviously a big increase from a few years ago, where the payment, and maybe say in 2018 the average payment might have been let's say $20,000 even potentially. The median ransom payment, as Coveware noted in their report, actually went down a little, and they say that is reflecting a shift in ransomware threat actors focusing on what they call mid-market companies or organizations, where the profile, the risk reward profiles may be a bit more favorable than these high profile attacks. So anyway, all this to say that the ransom demands and payments are certainly increasing and have been increasing over the last few years drastically. And as a result of that, as you can imagine, with the profitability of these attacks increasing, more criminals are trying to get into this space, and therefore there are more attacks. So it becomes sort of a circle in of itself. And another factor for why these attacks is increasing and the ransoms are increasing is this double extortion method that I referred to earlier. So as I said, a ransomware attack is just a virus that encrypts files, and you have to pay a ransom to get the tool that's required to decrypt them. However, in the last few years, we've noticed a trend that the criminals that undertake these attacks will also take copies of files from an organization's system before they encrypt the files. And so will threaten to publish those copies of files that they take in if a ransom is not paid. And so it's sort of a double extortion. There's an extortion for getting the tool to decrypt the file, but also an extortion to prevent them from publishing the files that they've taken. And they often will publish it on what they have websites, either on the dark web or the regular web, and sometimes even have social media accounts and things like that they will publish samples to. So as a result of that, that's a very common trend in the last few years. It's kind of actually become the standard now. So that same Coveware report that I referenced for Q2 2022 notes that 86% of ransomware cases now involve a threat of exfiltrated data. So it's really just become the standard in these types of cases, this double extortion. And so as a result, ransoms are sometimes being paid now by organizations, even if they don't need the decryption key to decrypt the files, because maybe they had a backup that was viable, and so they don't actually need they have a previous copy of the same file that's now encrypted. So, but organizations might still pay just because of this additional extortion method that I referred to, this publication of data threat. That has, increased the amount of the payments as well, because now organizations sometimes are paying for two things rather than just one thing. An additional extortion tactic that we're noticing beyond this new double extortion, or relatively new double extortion method, is that threat actors are trying to put pressure on organizations that they've infiltrated or compromised to make payments by communicating to their staff or to their customers or to their suppliers or others, or even the media directly. And so they might say, email, maybe while they were in the system, they got a copy of your customer list. And so they will take the email addresses from that customer list, send an email to that customer list and say, hey, we've attacked company X and they're not paying us a ransom. We've taken your sensitive company information that was on company X's server, and if you should talk to them and tell them to pay us so that we won't release this data. And so that's obviously a pressure tactic to try to increase the likelihood of the payment being made. And so that can, as I said, can go to customers, it can go to staff, it can go to the media directly even. So these forms of disruption are just methods to try to increase the likelihood of a payment. And so another one will be what you'll see on the slide, a DDoS attack, which is a denial of service attack. That's another way of just trying to disrupt your operations and therefore pressure you to make a payment that you might not otherwise make if those disruptions were not happening. I'll just lastly note that it's relevant to note that the Canadian Centre for Cybersecurity, which is a government entity responsible for cybersecurity issues, has warned of increased risk to critical infrastructure in Canada from Russian state actors. And obviously that's that warning's even more prominent now given the war between Russia and Ukraine. Next slide, please. Great. One more trend I will talk about is just the increasing varying nature of the attack vectors that these threat actors use to get into your system in the first place, to spread this before they spread this ransomware. So a few years ago, it was very common that a threat actor would get into an organization's system by what was referred to by technical people as an open RDP port. Basically, it's a part of your computer network that's open to the internet that anyone can kind of see and potentially access. And there were a lot of such things that were not protected by some kind of firewall or outer layer of protection. And so that was a very common way and threat actors would access an organization's systems. However, in the last few years, we've seen a varying methods for getting into systems now, including phishing emails that might have a virus attached to them, or result in a compromised username and password, social engineering attacks, and software and network vulnerabilities that might exist. Even some methods that have been implemented by organizations to prevent these types of attacks, these varying types of attacks, are sometimes failing. So for example, multi-factor authentication is a common way that organizations will try to prevent phishing emails from having a significant impact. So a phishing email might be something like, hi, you've received a voicemail from, or a message from, X person, please click this link, and then you open the link and it's asked you to enter your computer, your organization's username or password. And so maybe an individual user does that by accident, they're not thinking properly, and they enter their username and password. But now multi-factor authentication is designed to protect that, because even if the threat actor now has your username and password that you've entered into this web page, oftentimes organizations will have multi-factor authentication that requires a user to enter a token from their phone or accept a notification from their phone before access can be granted the account. However, have been recent attacks actually that will basically what's called MFA fatigue, where essentially the threat actor will log in with the username and password, and they don't have the user's phone, so they obviously don't have the token, but they will send multiple authorization requests to the user's phone, like, hey, let me in, hey, let me in. And the user might just eventually get annoyed with that and think that, and just accept one of those authorization requests, even though, you know, they're not the one that's logging in. So that's just called an MFA fatigue. So all that to say, the types of attacks are constantly changing. The methods that the threat actors use are constantly improving and changing, and so the security measures that organizations need to implement need to constantly adapt and change as well. You know, security measures from 5 years ago are not going to be, you know, up to standard now necessarily, because of the changing nature of the attack vectors. Another topic that we wanted to just make sure we covered is respect to liability and sanctions concerns. So you might be asking yourself, you know, isn't it a crime to make a payment for a ransom payment like this? The answer is that it is a crime in Canada to give financial aid to individuals and organizations that are deemed terrorist organizations or otherwise on applicable sanctions lists from certain countries, for example. But it's not strictly a crime to make a ransom payment. But as a result of the fact that it might be a crime to make payments to certain individuals, when you're an organization considering paying a ransom, you have to make sure you're conducting due diligence, you know, contemporaneously, in order to show that you undertook reasonable steps to try to ascertain the identity of the attackers, to make sure that you weren't paying a sanctioned terrorist organization or an entity or individual under a sanctioned list. And there are penalties for violating those Canadian sanctions, but you know, sometimes those penalties will include what are referred to as knowledge qualifiers. Basically, as I said, the qualifiers that will account for the fact that maybe an organization did take the appropriate due diligence steps to try to make sure they were not paying a sanctioned entity. So you need to be in a position to be able to demonstrate that you took those steps. You can't just, you know, blindly make a ransom payment and you know, just hope for the best. You need to show that you tried to ensure that it wasn't to a sanctioned organization. And so the companies that I mentioned, like Coveware before, which is a ransom facilitation company, will do those sanctions checks for you, and you should also, of course, look at them. But those kind of checks are done for you to make sure that you know, you're not clearly making a payment to a sanctioned entity. These kind of issues, though, are certainly, the concerns around them are increasing. Perhaps even, you know, arguably more. There's more focus in the U.S. right now on ransomware and ransom payments. In the United States, the Department of Treasury of Office and Foreign Assets Control, which is also called OFAC, released guidance on this issue. And any Canadian organizations with ties to the U.S. should be, you know, be aware of those risks and expectations. So basically, the guidance says, you know, that the U.S. government, of course, discourages private companies and citizens from making ransom payments. You know, it talks about how OFAC has designated, you know, numerous malicious cyber actors under sanctions programs. How there may be civil penalties for making such payments, like there are in Canada. And it refers to the fact that in the U.S., you know, it's a strict liability offense. It also refers to the fact that, you know, these issues, making sure you've done due diligence and have a sanctions compliance program, those also would apply to companies that, you know, not only the organizations that's making the payment, but even those organizations involved. So that might be your insurance company that maybe reimburses you for the payment, or the ransom facilitation company that helps you make the payment, or other, you know, other financial service companies that might be involved in the process of processing ransom payments. So certainly, you know, something that is a big focus and concern in the U.S. in particular, but everywhere right now. And a lot of that has to do, of course, with the Russian-Ukraine war as well, because there are now heightened sanctions concerns due to that war and the additional sanctions that have been placed on Russian entities and individuals based as a result of that war. And President Biden actually has recently, or fairly recently, signed relevant executive orders, one of which actually sanctioned a cryptocurrency exchange that was, the government said, was enabling ransomware payments. So basically, you know, put in a sanction even just on a cryptocurrency exchange that was not actually making the payment itself, but just an exchange that was enabling the payments. So Just an example that I'll note as well that's sort of interesting is in relation to a ransomware group called Conti, which you see referenced on the slide. Shortly after the Russian-Ukraine war, this ransomware group came out in favor, sort of put out a statement in support of Russia, basically. And as a result of many ransom facilitation companies and others involved in the process of ransom payments, basically decided to stop making payments to that threat actor group, even though they were a very prominent group at the time that did these kind of attacks. So, certainly a lot of heightened concerns around the Russian-Ukraine war situation as well. Just the last point I'll mention before I maybe turn to a couple questions that were asked was the potential consideration of bans on these kind of payments. There has been some discussions in the US in particular that have contemplating banning ransomware payments altogether, including some high-profile US government officials who have commented that they believe that payments should be banned. And so, for example, Florida and North Carolina have forbid their government entities from making these ransomware payments in the last few years. So it's certainly an issue worth watching because these are interesting trends that might result in different issues down the road. I'll just quickly turn to two questions that were asked before I turn it over to Kateri-Anne to talk about service provider incidents. One of the questions that has been asked by one of the attendees is, what factors should be considered in whether or not to pay a ransom? So that's a very complicated question that I'll try to just answer at a high level. But I think there's many factors to consider is the short answer. The longer answer is that some of the factors you should consider are, do you as an organization have backups of the files that are encrypted? So if you do have backups, maybe you don't need to pay for a decryption key because you can just restore from a backup copy of the file that's now encrypted. But maybe your backups are encrypted, or maybe the backups are old. So you have backups of files from last month, but not from this month. And so those are all factors you should be thinking about. Some other factors are, how long is it going to take to restore from backups? How much will it cost to restore from backups? Maybe the cost of that is even more than the ransom payment itself. And so that's something to think about. Another point to think about is, are you sure you've actually, kicked the threat actor out of your system? Maybe they still have a backdoor into the environment. You pay them the ransom, and then they're just back to the system again and encrypt it again. So you want to make sure that you've kicked them out or your system is secure before you make a ransomware payment. Another factor to consider is, how much time do you have to negotiate? Generally, the more time you have to negotiate, the more of a discount off the original ransom demand you can get. But maybe you don't have a lot of time. Maybe your organization is a hospital or something, and you just need the data to provide care. So it depends on the type of organization you are and how much time you have. Another factor to consider is, as I said, the cost of restoring the backups, and both in terms of labor, but also technology, and also like the business interruption losses that you might be taking on a day-to-day basis by not having access to your computers. Maybe those all outweigh the amount of the ransom demand that's being demanded. So it might come down to, honestly, like a cost-benefit analysis there, and to some extent. Another factor to consider might be, what type of files do you have that are encrypted? And the reason for that is that some files are, just by the fact that they get encrypted, corrupted. And so even if you get the decryption key, you won't actually get the file back because the file just got corrupted naturally in the encryption process. So if you have a lot of those types of files, maybe making the payment is less attractive to you because you have a lot of these files that you're not going to get back anyway. The last factor I'll mention right now, but there are many more, is what files are the threat actors threatening to publish in this double extortion method I referred to. If they're threatening to publish very sensitive files, then maybe you want to make a payment to try to prevent the publication of those. Or maybe they're not threatening to publish very sensitive files, and maybe that makes the payment less attractive to you. So as I said, those are just some factors to consider. There's lots more that I don't have time to get into the whole discussion, but those are some that I'll mention. And then the second question I'll answer just very briefly is, someone asked, if negotiating a ransom, what is the approximate percentage of the original demand that you could negotiate? It'll depend a lot on the factors I just mentioned, perhaps most importantly, the time. It'll also depend on the threat actor group. So there's no real direct answer I can give you, and some of this will depend on what the ransom facilitation companies might tell you about their experience with the threat actor. But in our practice, I can say that, discounts of 30% are very common, and discounts, we've seen some discounts up to as high as 80 or 90%. So it is possible to negotiate these demands, but there's a lot of factors that dictate how much you can negotiate. So with that, I will turn it over to Kateri-Anne to talk about service provider incidents. And if we go to the next slide, please.
Thank you, Daanish. There's so much to say on this topic. I will complement this topic by talking about service provider incidents. So service provider incidents are very important in the last years, both in terms of numbers and also on the financial consequences of these breaches. As we know, many companies nowadays have service providers or subcontractors who will be in a position to handle data, including personal information. Whether it is that these service providers are actually hosting data, for example, or that they, through a VPN, for example, have access to the client's environment to execute a specific task and have access to some of the data. So we've seen examples across Canada, Europe, and United States involving payment processors, payroll, employee information service providers, etc. Also, service providers incident can have, as Daanish mentioned, both an operational consequence, so you're not, as a client, receiving the service for which you're paying, and that can have consequences for the client because they cannot, for instance, use the technology to pay employees, or they can't use the technology to track employee in the workplace, etc. So this can have operational consequences for the client, but also reputational and financial consequences if personal information is disclosed, for instance, as a result of the incident. One of the questions that is asked almost all the time is, who actually owns the breach? So if I'm a client, I do business with a service provider, they have access to personal information, they host personal information, and they get hacked. So what are my responsibility as a client? Well, basically, Canadian laws, Quebec laws, US laws are pretty similar in applying the principles that it's actually the organization who collected the data and hands it over to the service provider who has the liability. In PIPEDA, one of the principles that is in PIPEDA is accountability, and PIPEDA states that an organization is responsible for personal information in its possession or custody, including information that has been transferred to a third party for processing. So the liability remains in the hands of the client who handed over the personal or gave access to the personal information to the service provider. Incidents.
Sorry, Kateri-Anne, I think you may.
Sorry, yeah. I think okay, sorry. Yes, I was saying that there are some fallouts and consequences. So if you're in the shoes of the clients, obviously you should have an incident response plan, and this incident response plan should include a scenario where some of your major or important service providers notify you of a breach. When you're in the client's position, I guess one of the expected fallout is that you might not be the only client affected. There are probably going to be several clients affected, and the service provider will ultimately be extremely overwhelmed with requests and demands for information. And so it might take a while before you actually get information on what's happening. And you will not have entire control on the investigation, even though contractually you can ask to be notified and you can ask to be kept appraised of what's going on. We often see that us as law firm, one of the examples is that we are often asked if we are I've been appointed to deal with a service provider breach because sometimes it can be a strategic advantage for clients to regroup into one law firm that is already handling a service provider breach so that you can have more leverage if you represent more people. One of the fallout on a very practical point of view is that as a client, you control the knowledge of what you gave to the service provider, what they have access to. This is information that should be easily accessible, but you don't control the other client's information, reaction. So if, for instance, one of the affected client goes public with the fact that the service provider was breached and that there are consequences on personal information, then it may not necessarily be the route that you would have taken, but you can be a bit pressured and a bit, you can be a bit pressured with going public yourself, or at least handle internal communications because of other clients' reaction to the breach. I have to say also that in the upcoming Quebec reform that is going to take place, starting from September 22nd, 2023, clients who want to do business with service providers will have additional obligations. One of them is that if you are planning to give access to a service provider or communicate to a service provider outside of Quebec personal information, you will have to conduct a privacy impact assessment, and you will have to demonstrate at the end of this assessment that the personal information is going to receive adequate, is going to be securely and adequately protected, like it would be if the service provider was based in the province of Quebec. And also there will be requirements as to what should be in the service provider's agreement, and I'm going to talk about that a bit later on. I think, can we just move to the precedent slide, please? I think we're one slide too far. Yeah, sorry. So in terms of key incident response steps, if you are involved in a service provider incident, well, if you are a service provider, I would say that one of the key things to be very mindful of is your contractual obligations, and also the risk of being held responsible for the consequences of the breach. So I think as much as you want to keep your client in the know of what's going on, you want to act responsibly, you want to inform them, you also want to be thinking pre-litigation mode, privilege, not giving information that has not been verified, and be mindful of the fact that you could, of course, get sued because data has been compromised, or because the services have not been rendered. If you're a client of a service provider, then I think you need to push to obtain as much information as possible, and you need to have good records of what exactly was shared with that service provider in order to do your own assessment and evaluate what type of data may have been compromised, and also whether notification obligations will be triggered. I think it's definitely if there is personal information compromised, you should get the advice of external counsel or internal counsel to plan any notification obligation, and to also have a very frank conversation with the service provider about who's going to be paying for these efforts and who's going to be covering any mitigating measures, such as, for instance, credit protection. Contract considerations are extremely important. So over and above the obligations you have under PIPEDA, in Quebec there will also be obligations regarding service providers, whether they are located in Quebec or outside of Quebec. There will be mandatory security clauses to be inserted to make sure that in accordance with the sensitivity of the information, the service provider has taken adequate measures. There will be mandatory clauses to insert in terms of restricted use of personal information by service provider, how long the personal information can be retained once the agreement or once the services are no longer required, and also mandatory audit clauses to be inserted so that the client can actually verify whether the security measures and whether the contractual obligations are complied with. So this is actually your best protections. And also be mindful of any contractual clauses regarding indemnification, jurisdiction, arbitration. When you're a client and a service provider is the victim of an incident impacting the personal information in your custody, then of course, as the company responsible towards the individual clients, you can be sued. You can be sued in a class action. You can be investigated by the regulator, and you want to be able to force the service provider to collaborate, and also you want to be able to bring the service provider in any kind of lawsuit that you're involved in. If you have arbitration clauses, or if the indemnification is capped, then this is going to be a major obstacle in addressing this situation and counter-suing the service provider for the costs that you may have incurred. So be very mindful of these provisions when you negotiate your contracts with service providers. I think I'll move on to Quebec's new notification obligation. So we had been waiting for the Quebec government to introduce privacy, confidentiality, or security incident reporting obligations in the law. So in the midst of the reform that we just had, this is exactly what was done. The new provisions are not that different from what we saw in PIPEDA and PIPA in Alberta. So this is not like a big revolution, but at least it puts Quebec on the same level as the other provinces. These new provisions regarding notification of confidentiality incidents are already into force. So they came into force on September 22nd, 2022. So since a couple of days now, as a company, you need to be able to detect, assess, mitigate, and resolve confidentiality incident, and also notify when there's a risk of serious injury, these incidents, to the Commission d'accès à l'information, as well as to the affected individuals. The definition of confidentiality incident is very broad. It does include access not authorized, use not authorized, communication, loss of personal information, and also any other kind of breach. There's an emphasis here on use, because other laws don't necessarily consider the unauthorized use as a breach, but Quebec has introduced the unlawful use of personal information, which will include snooping, for example, an employee that is consulting or using personal information that's not on a need-to-know basis. The notification trigger is the risk of serious injury. That is pretty similar to the Roche criteria. In order to assess the risk of injury, you need to consider the sensitivity of the information concerned, the anticipated consequences of its use, whether it was, for example, due to a hacking or external person, or whether it was, for example, a human error in the company that can be handled by having a satisfactory solution to erase or to mitigate the harm, and the likelihood that such information will be used for injurious purposes, which is almost the case in everything that Daanish actually described in its section. So you will need this will need to be assessed, usually with the help of external counsel, breach coach. But there's a mention in the law that the person responsible, so your privacy officer, the person responsible within the company for protection of personal information, must be consulted when this analysis is done. Also, notifying regulator affected individuals is provided for in a regulation that was recently, like the draft was published this summer, so everything that needs to be in the notification is addressed in the regulation, pretty similar to what we see in PIPEDA and PIPA. The regulation for some reason has not yet been finalized, so usually it's done within 45 days of the publication of the draft, so we're anxiously waiting for this draft to be passed as regulation. This will follow. And the last thing I would mention is that, as the case is for PIPEDA, there has to be an incident register kept by the company for all confidentiality incidents that occur, not only those who get reported, but all confidentiality incident. And this register must be kept for 5 years. So the time period for PIPEDA is 2 years. From the discovery of the breach in Quebec, it will be 5 years, and the commission, the regulator, the Commission d'accès à l'information, will be able to ask to consult this register. So obviously a lot of training to do, because be very careful about what you put in that register as well, because this will be obviously asked from you if you are in a litigation following a privacy breach. So a lot to say about that as well. I hope this answers some of your questions, and I'll hand it over to Alex for his portion.
Great. Thank you, Kateri. And maybe I know there's one question that's come in, and there were a number that were received in the theme of jurisdiction. So, you know, for companies maybe with limited presence in Quebec, but who may collect information about people in Quebec or do business with folks online. You know, I don't know if without crossing into providing legal advice, is there a quick consideration in terms of some of the factors that might trigger the application of the Quebec law to a company?
Yeah, so I think the two factors are whether one is collecting personal information from Quebec residents, and the second factor is whether this is done within in the course of an enterprise or doing business in Quebec. So that may be the second factor is more subject to interpretation, because then, as you said, a company may be outside of Quebec and not necessarily soliciting the Quebec market and not offering services to Quebec residents. So the collection will be, let's say, either a minority of cases or almost accidental. So I think there would be arguments there to say that the law doesn't apply to that company. However, a company even located outside of Quebec who that actively markets that is active in the Quebec market and solicits customers in the Quebec market collecting personal information, then I believe would fall under this jurisdiction. And as you know also, Alex and Daanish, when information is transferred from one province to another, then this gives rise to the application of PIPEDA. So I guess that's the short answer I could give to this question. But yeah, it's an interesting one, especially now that the penalties are not aligned from one province to another. So right now, you know, committing an offense in Ontario under PIPEDA is less costly, let's say, that committing a violation in Quebec if the Quebec law applies, because the sanctions are so high. So this will probably be maybe leveled with C27 that you're going to talk about. But right now, this is a very interesting question.
Great, thank you. So we could go to the next slide. So in the few minutes that we have left, I'll touch on some of the topics I mentioned at the outset. So some board issues, privilege, and then some law reform pieces, and we'll try to catch some of the other questions that have come in as well. So in terms of some of the governance issues that we see and current trends, board focus on cybersecurity is not new, of course. I mean, there has been long an interest on the part of boards driven by liability concerns and discharging their duties to drive behavior. So we see, you know, cybersecurity is regularly on the agenda. There are appropriate experts involved in advising the board and reports being provided to the board on cyber risk and what measures are in place to mitigate and manage those risks. And boards have been paying attention to that for some time. Lawsuits against directors, frankly, haven't mostly gone very far, and so where they have arisen, there has been a demonstration of the appropriate steps in place. However, I think in recent time, and particularly over the last year, we've seen a pretty strong increase in board appetite for interest around cyber incident response, preparedness, and testing in particular. And so very regularly we see boards asking for tabletop exercises to be conducted with the board directly, or in actual breaches, boards becoming much more active in the actual response to the breach, which in some cases leads to almost a second level of consumption of time in terms of how you're managing a response to an incident, where you have a lot of detailed questions being raised by boards about steps that are being taken. Ransom payments and other topics, of course, would be high on those lists, and the need to have discussions on those topics. So these are some of the challenges and some of the actions that we see. I think one of the practical things to offer a suggestion for consideration about how you can effectively address this is that we find it quite effective rather than conducting, for example, a tabletop exercise with a board, which doesn't really reflect how a board would or should be operating in any event in terms of their role. That what's presented to the board is a scenario that that is a scenario that management has actually conducted as a tabletop exercise, and along with the scenario, present the proposed management response to each of the factual developments that occur during the exercise, and present that as here's the scenario and how management responds. And then the use of that type of exercise is a really effective way to achieve some key objectives vis-a-vis your board, which I've identified on the slide here, and ensure that there is clarity about their role, about expectations, and that you have alignment on those as part of your planning. So in terms of escalation criteria, obviously with the presentation of the scenario and the management response, you would include in that at what point the board was notified and how also that occurred. So in terms of when, oftentimes those are triggers which are tied to incident criticality definitions in your response plan. So if you have a severity 1 or severity 2 incident, certain types would be the kinds that you would say should be going to the board. And let's make sure everybody's on the same page about that. Similarly, on a process perspective, is it going directly to the board chair from your CEO or from another particular individual? Is it going to a committee? Is it going to the full board? Is the chair left with some discretion how to handle that? Those are questions that you can effectively work through in review exercises like that if you haven't already addressed those topics. And then further, in terms of the role of the board, making it clear as to what that role is through that type of review and exercise. The final piece that I reference on the slide here is a reminder, and I'll touch on privilege in more detail in a moment, but the privilege protocols that will be part of your incident response planning also need to extend to the board and any reporting that's taking place to the board. And so there can be very important reminders that should be taking place to the board when reporting in dealing with a cyber incident, that it is highly sensitive and confidential. This is not the time for casual discussions and information sharing with other peers and whatnot, absent some specific decision making around that. And that whatever usual protocols would be followed for the sharing of privileged information with the board need to be followed in this context as well. One of the other questions that we also get quite frequently is the extent to which the board should be creating minutes of meetings relating to cyber incidents and frankly other cybersecurity topics more generally, but incidents in specifics. And again, without veering into the realm of providing any legal advice, of course, this is just for information purposes, but generally speaking, less is more. So, minutes should be taken, of course, by the board. We do get this question quite a bit to demonstrate that it's discharged its duties, but that is recording that certain topics were discussed without getting into the details, so that, and you're very cautious, of course, about privilege as well. So, not getting into the content, concerns raised, opposing views, and debate, but more that there were certain topics that were discussed. And so that's some of the kind of practical things that we're seeing arising vis-a-vis the boards, and some ways that they can be addressed. The next slide, if we could switch to that, just a little reminder about privilege. And so privilege, like a board interest in cyber risk, is not new. So privilege has long been recognized as an important consideration in incident response planning and in the conduct of responding to cyber attacks. The protocols that you should have in place should be baked right into your incident response plan, so it's clear to everybody how they're to behave, how documents are to be marked, how information is shared, the conduct of meetings and the marking of meetings as being privileged, and how you're going to achieve the protection of privilege through your incident response process. That is important, of course, because the records that often you'll be generating in the context of a cyber incident investigation, and any forensic reports in particular, are the kinds of things that could be extremely harmful and damaging to your organization if they ever saw the light of the day, to a regulator or to an adversary in litigation if your incident does result in a class action proceeding. And so to the extent that it's appropriate to be claiming privilege over documents that you're generating through that process, it's quite important to be doing so. The additional trend that we have seen is on the second bullet here, which is that concept of seeking privilege claims in respective incident response investigations has also extended both to risk assessments and tabletops. Now, obviously, those are not ones where you're anticipating proceedings, but to the extent you are engaging parties to produce reports for your organization about where your cyber gaps are and cyber risk maturity is, or benchmarking against your peers, et cetera, those could be and increasingly are structured as being engagements for the purpose of assisting counsel in providing legal advice to the company about what to do about those facts. And so while privilege will never protect the facts, the reports and documents that may be generated there are things which, again, could be extremely unhelpful and harmful to your organization, and are ones that where you, if it's appropriate to claim privilege, should be considering that. We do see that quite often now in our practice as well. Additional privilege issue that we've seen in recent trend is that there is a great increase in organizations seeking to have on retainer their key incident response providers. So that might be your forensic investigation firm, it could be your ransom negotiation payment firm, law firm, of course, PR firm, and others. The highest priority is the incident response firm who would be performing forensic investigation work and security services, just given the criticality of the services they're providing. And the reason why the retainer topic has come to the fore is that in recent years, where there have been what we call surge events, so cyber events that affect thousands of companies around the world, Log4j, SolarWinds, Exchange, these issues impact a wide range of companies. And in the heat of the response to those surge events, the top providers are not available. So they run into capacity issues and cannot service everybody who is asking for help. And so the retainers can guarantee availability contractually with those providers, so they'll protect their ability to service their contract customers. And so we increasingly see that as a topic that's high on the list for organizations. That development, though, does have some pretty important privilege implications, which I won't delve into the mechanics of it here, but it does require some care in how those engagements are set up and papered. And so certainly would strongly recommend getting advice about how you're going to continue to maintain privilege over incident response investigation work if you are putting a firm like that on retainer through a service agreement. And then lastly, on privilege, there's a question of waiver, and some of the more frequent issues around waiver arise currently in auditors seeking access to very detailed information about cyber incidents and forensic reports included, law enforcement and regulators in particular. So anytime you're sharing information with a third party that is privileged, you have to be asking the question whether this is waiving privilege in part or for a particular purpose, and whether also you ought to be taking steps to try to avoid sharing privileged documents and achieving the needs of those parties in a different way that reduces the risk of a waiver of privilege. So caution needs to be occurring there, but certainly those are the three main categories where we see there are requests from external parties to get access to these things. So that's a current issue. And then finally, if we could switch to the next slide, just wrap up here. I won't go into this in any detail. So just to highlight that there is very significant law reform happening in Canada currently, Bill C-26 and Bill C-27. C-26 is a cybersecurity bill that deals with the federal sector and operation of vital systems, banks, telecoms, energy, transport, et cetera. If you are in those sectors and or a service provider to those sectors, this is something to really pay attention to. There are very significant changes that would be brought in with that legislation, and to monitor the development of it as it evolves. And there are undoubtedly going to be consultations and the availability of opportunities to make your views known. So definitely pay attention to that. And C-27 is PIPEDA reform, but PIPEDA reform with extra muscle. So very significant amendments to our privacy statute, including order-making powers for the commissioner, establishment of a tribunal to hear appeals, the ability to levy fines and penalties, regulation of artificial intelligence, and numerous other aspects. In the handout, we have included bulletins on each of these bills, which go into a lot more detail, of course, and certainly encourage you to take a look and pay attention to those as they work through the process of evolving and then ultimately potentially becoming law. I will just close out my comments just with addressing a few very specific questions that were raised prior to the session. So one was about class actions. There certainly continue to be a lot of class action activity in Canada. The Ontario Court of Appeal recently heard appeals in several cases, which will address whether the intrusion upon seclusion tort claim is viable against companies that are hacked. And so certainly be watching for that to be released. Those decisions are under reserve. A lot of questions about the insurance market, cyber insurance market. No secret that there's been a lot of change in the cyber market over the past year or a bit more. We certainly hear about increased premiums and greater scrutiny in the underwriting process, none of which I think should be very surprising given the market. However, certainly we see a lot of work and work with a lot of clients who have cyber insurance, and so it is extremely prevalent still, I would say, in our practice. And also that we do see insurers are continuing to pay out the costs associated with these attacks. So some of the questions were geared towards that, and I just offer that as a comment based on our experience. There was some also question about those issues of insurance claims and costs and whatnot. And for further reading, this is not in the materials, but I just commend to you an organization called Net Diligence produces an annual study of cyber insurance claims, which takes in a lot of data from different insurers and compiles that into aggregate statistics around costs for different types of providers and based on different types of matters and industries, et cetera. So again, net diligence cyber claims study. It's put out every year and certainly has a lot of different information that may be of use. With that, I see that we're at time, so we'll wrap up there. Turn it back to you, Dan, and thank you everybody very much for your attendance and for submitting the excellent questions, which I hope we've addressed. And feel free to reach out to us, of course, directly if you had questions that you'd really like to have addressed that we didn't get to today. We'd be happy to connect with anyone.
Absolutely. Thank you for that, Alex. I would just like to say an enormous thank you to all of our speakers today, Alex, Kateri, and Daanish. As mentioned, as Alex just said, any unanswered questions have been forwarded onto the panel, but please do get in touch if you did have a question that wasn't answered. And we will also make a recording of this webinar available to you. On behalf of Mondac, the Canadian Corporate Counsel Association, and Fasken, thank you very much for joining us and have a great day.